How do you sell inherited property with siblings? Selling inherited property with siblings starts by confirming who has legal authority to act, choosing whether the family will sell, keep, rent, or buy out one sibling, and putting price, expenses, and proceeds in writing before listing. I'm Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA, and when probate or trust administration is involved, an estate or probate attorney. The hard part is not just the house, it is the grief, the money, the memories, and the family roles all landing at once. A simple sale can turn into a long family fight when nobody confirms authority, nobody tracks expenses, and nobody agrees on the plan before the listing starts. Why do siblings struggle to sell inherited property? Siblings struggle to sell inherited property because emotional attachment, financial pressure, unequal caregiving histories, and different goals collide in one transaction. One sibling may want a fast sale, another may want to keep the family home, another may feel like they already did the most work caring for mom or dad. Another may be worried about taxes, debt, or whether they can afford their own life without the inheritance. That does not mean your family is broken. It means the situation is loaded. What is usually driving the disagreement? It is usually one of four things: price, memories, money, or workload. Separate those issues early so you do not treat an emotional disagreement like a pricing problem or a money problem like a character flaw. The first step is to put the facts on the table: who owns what, who has authority, who is paying carrying costs, and who will be the main contact for the broker, attorney, CPA, title company, or probate court. How do siblings legally own inherited property? Siblings usually inherit property in one of three ways: as beneficiaries of a probate estate, as beneficiaries of a trust, or as titled co-owners after the property has been distributed. If there is a will, the will may control who inherits, but the executor usually needs probate authority before managing or selling estate property. That authority often comes through court-issued documents such as letters testamentary or letters of administration, depending on the state. If there is a trust, the trust document controls who benefits, and the successor trustee usually handles the sale according to the trust terms. If there is no will, state intestacy law controls who inherits, and the court may appoint an administrator to act for the estate. Can an executor sell a house without all siblings agreeing? An executor may be able to sell estate property when the will, court authority, and state law allow it, but beneficiaries may still have notice rights, objection rights, or practical leverage depending on the situation. That is why the family should confirm title, authority documents, ownership shares, and any court approval requirements before anyone talks about listing. Do all siblings have to agree to sell? All titled co-owners generally must sign a voluntary sale, but an executor or trustee may be able to sell estate or trust property without every beneficiary signing if the documents, court authority, and state law allow it. That distinction matters. If the home is still inside the estate or trust, the person with authority may be the executor, administrator, or successor trustee. If the property has already been distributed to the siblings as co-owners, then the siblings are usually the sellers, and every titled owner generally has to sign unless a court orders a sale. Can one sibling block the sale of an inherited house? A sibling can block a voluntary sale when their signature is legally required, but if they are only a beneficiary and an authorized fiduciary is selling, their objection may not stop the sale by itself. It can still cause delay, expense, and family conflict. In practice, legal authority is only half the battle. The real goal is to get aligned before resentment turns into litigation. What are the main options for siblings who inherit together? Siblings who inherit property together usually have four paths: sell and split the proceeds, arrange a sibling buyout, keep and rent the property together, or hold the property temporarily while they decide. Selling is often the cleanest break because it turns the house into cash and ends the shared responsibility. A buyout lets one sibling keep the property while the others receive their share. Renting can work if everyone treats it like a business. Holding temporarily can make sense for a short decision window, but doing nothing often becomes expensive because taxes, insurance, utilities, maintenance, vacancy risk, and conflict keep accumulating. How does a sibling buyout work for an inherited house? A sibling buyout usually works best when the family agrees on fair market value, documents the buyout terms in writing, and confirms whether the buying sibling needs cash, financing, or a refinance to pay the others. If the group wants to keep the asset as a rental, get a written co-ownership agreement first. It should cover expenses, management duties, rent decisions, repairs, insurance, exit rights, and what happens if one sibling wants out later. How should siblings prepare before listing the property? Before listing inherited property, siblings should agree in writing on repairs, timeline, price expectations, expense sharing, personal property, and who has authority to communicate with professionals. Use an independent appraisal or broker comparative market analysis to set expectations, and do not rely on an online estimate alone. Document every dollar spent on property taxes, insurance, utilities, mortgage payments, repairs, cleanout, lawn care, HOA dues, and security. If one sibling advances money, write down whether that amount will be reimbursed before proceeds are divided. How should siblings split expenses on an inherited house? Siblings should track carrying costs and sale expenses in writing, then reimburse approved advances from the closing proceeds, or divide them according to the will, trust, ownership shares, or family agreement. The personal property inside the house is often where emotions spike. Inventory the contents, set deadlines, and decide what gets claimed, donated, sold, stored, or removed before the house goes active. What happens if one sibling refuses to cooperate? If one sibling refuses to cooperate, the family should first try a documented buyout discussion or mediation, and only use court action, such as partition, as a last resort when the dispute involves titled co-owners. A partition action is a lawsuit asking the court to divide or sell co-owned property. It can force a sale when a voluntary sale is impossible, but it is expensive, slow, and adversarial. That is why it should come after negotiation, not before it. What if one sibling wants to live in the inherited house? The family should decide whether that sibling will buy out the others, pay rent to the group, cover carrying costs, or move out before listing. Leaving the arrangement vague is what creates the fight later. If one sibling is doing all the work, acknowledge that openly and deal with it fairly. If the disagreement is really about communication, bring in a neutral mediator, probate attorney, trustee, or independent broker before the relationship gets worse. What should siblings do first? Siblings should first confirm legal authority, choose the path forward, document expenses, and designate one point of contact before they list or transfer the property. That gives the family a clear process before the listing, before the arguments, and before the delays. It also helps the broker, attorney, CPA, title company, and court deal with one organized family process instead of scattered instructions from multiple heirs. If you inherited property and need help finding a broker who understands estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free.